watching Left, Right and Centre this Thursday night. I'm Nidhi Razdan. On the programme this evening, Sahara boss Subrata Roy completes a month in Tihar jail and will spend more time there as the Supreme Court talks tough, telling him to cough up 10,000 crores for his bail. Sahara insists they don't have that kind of money. But is the tough approach the best way to deal with Roy, or has jail become the norm instead of bail? My colleague A. Vaidyanathan has more.
Chief of Sahara Group companies Subrata Roy, along with his two directors, had spent 1 month in Tihar jail for not refunding money to investors as ordered by the Supreme Court. And he's staying there with a tough bail condition of 10,000 crore imposed by the top court. Today, Roy's lawyers offered a revised proposal to pay 2,500 crore up front and the remaining 5,000 crore within 21 days of his release. They also asked him to be placed under house arrest instead of jail. But the judges did not budge. The top court said, you have money to pay thousands of crore in cash. Why not pay 10,000 crore? We are in a hurry to finish the case.
The matter is still pending and we will continue our argument on 9th April at 10:30.
The court is now hearing Sahara's chief contention that the order sending him to jail is illegal and unconstitutional. SEBI batted against Subrata Roy and argued he could have sold his assets worth 20,000 crore and paid the money, but didn't. It is deliberate deficiency of Subrata Roy not to obey the court orders. Rebutting the criticism that the court was severe on the Sahara chief, the two-judge bench observed, don't interpret it as a punishment. It is just enforcement of court orders. We will get into punishment aspect once the contempt proceedings are over. 10,000 crore is not a bail bound. Out of 37,000 crore, by paying 10,000 crore, you will show your bona fide.
Tough time for the Sahara chief. He will have to wait patiently in jail to know his fate, as the top court will resume the hearing on the 9th of April. In New Delhi, Arunachalam Vaidyanathan, NDTV.
So is jail the norm instead of bail? I want to stress here that we are not going to prejudge the merits of this case. It's not for us to do that, but there is a principle that we would like to discuss. We have senior lawyer KTS Tulsi joining us tonight, senior advocate Aman Lekhi also with us. Sharat Pradhan, senior journalist who has followed the Sahara case in particular closely, joins us from Lucknow. And we also have Gaurav Kejriwal, counsel for Sahara, here in the studio with us. Mr. Tulsi, let me take this to you first. The Supreme Court has been very, very tough on Subrata Roy, and it really is astonishing the amount at 10,000 crores for bail. Do you believe that really that tough approach is called for, because the circumstances of this case are also unusual?
You see, of course, I think that the circumstances of this case are unusual because several assurances are given to the Supreme Court, and then those assurances, they go back on those assurances back and forth. And if it appears to the Supreme Court that somebody is playing tricks with them, obviously they will be very wary of trusting them the next time. But nevertheless, I believe that no one should have to go to jail for their inability to pay. Of course, the question really is whether they are unable to pay, or are they only trying to take the court for a ride. But there is a principle which has been upheld by the Supreme Court, that liberty is far more precious than money. And if somebody genuinely is unable to pay the money, then he should not have to go to jail. Even the husband who is unable to pay the alimony can be sent to jail. But there has been a lot of criticism. For any reason, a person is made to suffer imprisonment, lose his liberty, merely because of his inability to pay, then the poor persons are the ones who will bear the brunt. In this case, of course, they raised more than 20,000 crore illegally against the SEBI regulations, against the SEBI directives, and they violated, they committed several crimes for which action was sought to be taken, and they themselves came to the Supreme Court and gave certain assurances. Right. This case is of course very peculiar, but I am sure that the principle that a person should not have to lose his liberty merely for his inability to pay will still sustain itself for poorer people.
Let me take that to the former Attorney General of India, Mr. Soli Sorabji, who joins us as well. Mr. Sorabji, Mr. KTS Tulsi says that no one should have to go to jail for the inability to pay, and that the principle that liberty is far more precious than money is a basic principle that the courts should adhere to. But here in this case, Mr. Subrata Roy is, accused of something that is a very, very grave and a very serious charge of that runs into, tens of thousands of crores. Therefore, do you believe in this case the Supreme Court's tough approach is really the right one?
Yes. It's not a question of inability to pay. If a man earning 10,000 can't pay a debt of 5 lakhs, it doesn't matter. It's a question of complying with the undertaking given to the court. Mr. Tulsi said assurance. No, it's an undertaking.
There's no undertaking.
And they've been drafting with the court. Court has been indulgent to them. They come with different proposals at different times. First they say we'll sell the property, then they say it can't be sold. Look, court is not interested in putting him behind bars just for the sake of it. The court is interested to see that its orders are complied with. Otherwise the majesty of the court and law is over.
Okay, so you clearly believe that the court's approach is right in this. Gaurav Kejriwal, counsel for Sahara, is here with us as well. Mr. Kejriwal, however, many would say that Mr. Subrata Roy has brought this upon himself in the way that he has conducted himself, disobeying courts frequently and disobeying the Supreme Court as well, and therefore inviting their anger.
Well, I would like to say, first of all, the original judgment of 31st of August 2012 does not cast any obligation on Mr. Subrata Roy, Sahara, to make any payments. Secondly, there is no undertaking or breach of undertaking which has taken place, and therefore the question of making payment or making proposals came up during the course of the hearing of the contempt petitions, and therefore to say that he has violated a court's order is wrong.
Okay, but on this question of his own conduct, the open defiance of the Supreme Court.
Well, I would say that it was not defiance. His mother, who's 92 years old, was very unwell, and he had only requested that he may be exempted from a personal appearance for one single day, and that he would appear on the next day. He had given an undertaking.
Yes, and we saw the court's response to that. I'm going to get Sharath Pradhan into this, because Sharath, while there have been these important issues that Mr. Subrata Roy's arrest have certainly raised, what would you say on the principle of jail and bail? Generally, the principle is that you give jail in exceptional circumstances and bail is the norm. Has that been reversed?
No, I don't think the court. I think in this case, but in particular, we should salute the Supreme Court of India for having gone to this extent, because invariably people with tons of money manage to get away with murder. In this case, the common perception is that Mr. Subrata Roy's company had been systematically circumventing, violating the law, all kinds of law. It's not just this. And when it comes to, because they always felt that they were the law of the land, they were law unto themselves. And
I don't think
that
is the perception.
Simply because they had the kind of political clout they enjoyed.
Conveyed or which has
this is the common perception.
No, I think that is your perception,
Please
Mr. Pradhan. I do not agree with it. Mr. Subrata Roy has been a law-abiding citizen of India.
Fine. You are free to have your opinion. I am free to have my opinion. But the common perception about Mr. Roy is
that he has always respected the court's orders.
The rags to riches story, his rags to riches story is not.
He has surrendered himself to the police authorities.
Isn't the situation precisely because he did not respect the court and its orders?
Like I had earlier said, that his mother was very unwell.
We know what's the outcome of that is the point. Sharath Pradhan, just complete your point. Yes.
Yeah, I wonder if this gentleman will allow me to complete. I wish to point out that because of Mr. Subrata Roy's clout with the different political dispensations, he could get away with anything. And the way he violated the law, he could, the kind of the perception about him is that he is some kind of a megalomaniac.
But where is the violation of the law proved?
Above law.
Where is the violation of the law?
You can't do this.
Okay, let me take this to Aman Lekhi.
In every case, the way his whole modus operandi, the perception is that he has the black money of the lot of politicians bureaucrats, film
Again,
stars and cricketers. Other than the money which comes from very poor people, that poor man doesn't get his money back. Majority of them don't get it back.
Aman Lekhi,
Now, that is a
let me
different
bring you
issue-
in
issue.
here though.
But
Aman
here
Lekhi, I
nobody
remember
believes that he doesn't have.
Sure. Mr. Lekhi, I remember that when
Nobody
the 2G
believes that
case
he
was
doesn't have
happening,
that
we
kind
had
of
the
money.
same
It
debate.
is only
About, sorry, we had the same debate when the 2G, accused were being denied bail repeatedly by the Supreme Court. On the question of bail being a fundamental right, the norm is bail, not jail, and yet at that time also there was the same debate about whether that was being reversed. As a principle, do you see something changing here?
No, I personally find that what the Supreme Court has done is legally untenable. I completely disagree that you can justify it in any permissible or known norm. There are 4 or 5 issues which you have to deal with. One, Mr. Roy had asked for exemption. Exemption was declined, and because it was declined, he was ordered to be arrested. He was arrested pursuant to that particular order and then submitted an apology. The apology was accepted by the Supreme Court. Once the apology is accepted for his non-appearance, the reason for his continued incarceration ceases to exist. So if the reason for his arrest was his failure to appear, on acceptance of the apology, he can't possibly be kept in custody. One. Number two, if this is contempt, insofar as it is being alleged that it is the allegation is of contempt, then the requirement of contempt is a finding of active complicity or involvement. And whatever punishment has to follow has to actually follow the finding and not precede it. In this particular case, as far as I know, in no proceedings is Mr. Subrata Roy a party. And because he is not a party, there can't be any finding. And because there is no finding, there can't possibly be a conclusion of his involvement. So in this particular case, the haste is not something which can in any way be justified. There are some people who say that there is inherent power in the Supreme Court to do it. Now that power is derived from Article 142. But 142 will not in any way avail the Supreme Court, because that particular provision also has to be in consonance with law, and law requires that a person should be put to notice and be heard before he is condemned. In this particular case, the requirements too have been in some way violated. And in fact, in this particular provision can in fact be used by Subrata Roy himself, because whatever we've read in the newspapers, the SEBI has been given receipts of payments that have been made, and SEBI has also been given accounts of the payments that have been made, which SEBI is yet to verify. Now, when you deal with civil contempts, verification becomes absolutely mandatory. And if before verification you conclude contempt, that means actually putting the cart before the horse.
I'm going to take this point to Mr. Sorabji, that Mr. Sorabji, on the fundamental principle of keeping people in jail before a trial has taken place. Now, it happens in India all the time. And, Mr. Subrata Roy isn't one of those poor under trials that has to languish in prison for years before a trial begins. And therefore, do you believe that is the reason why this case is different? Or if you look around the world, a Dominic Strauss-Kahn can get bail in a serious case that he had to face. A Rajat Gupta can get bail pending his trial. Should those principles not apply in India as well? As a principle, not just in Mr. Roy's case.
It's not a question of Mr. Roy. It's a question of principle. You see, this case has different aspects. He has made statements, I believe, that he has paid the depositors, which have been found to be untrue. He's given proposals, then he retracts them by saying, no, the property won't be able to be sold because the title is not clear. So the impression given is, by the way, the matter is still sub judice. So I would say the prima facie impression given is that he's drafting with the court. He's musing the injunctions extended to him by the court. And if he gets over, because he can afford to brief counsel, 5 senior counsel, whose fees come to lakhs at every appearance, surely he can afford to pay some amount to the depositors to whom he owes the money.
Absolutely.
So you must see the context.
I'll take that to Mr. Tulsi. Mr. Tulsi, wouldn't you agree with that point? If he can afford the rich and powerful lawyers, surely he can afford to pay back the depositors.
Yes, I think so. I entirely agree with Soli. The question really is that the Supreme Court is concerned about the interest of millions of investors from whom money has been raised illegally, and then the party tries to play tricks with the Supreme Court. It says that it has returned investors, and when the scrutiny is made, it is found that the return is found to have been given to non-existent people at non-existent addresses. Now, that's a kind of a thing which the Supreme Court is dealing with, and the overriding concern is millions of poor people who have invested their money. The Supreme Court is trying to guarantee that their investments are returned. And if a person is is unable to see reason, then perhaps the only way is to prevent him from escaping, to prevent him from fleeing from justice. That's the only thing which the Supreme Court is doing. Since January 2012, the Supreme Court has been extending the deadlines, giving him one option after another. He agrees to one, then that doesn't work out, agrees to second, that doesn't work out, and that's the kind of a game which different lawyer keeps playing with the Supreme Court, and Supreme Court is no longer interested in being taken for a ride.